All right. Hello, everyone. Welcome to another session of Between Two Firms, or Two Ferns, as we have been debating the issue of words. And today we're going to focus a little bit on contractors and companies using contractors, and as it relates to potential issues you might have, as well as IP rights that might be of concern, intellectual property rights. My name is Jubin Dana. I'm with Dana Legal Services, and we focus on patents, trademarks, copyrights, and I'll let Marta introduce herself.
Good morning, everyone. I'm Marta Vanegas. My firm is called Vanegas Law Group, and we are an employment, small business, disability, and now family law oriented practice here in Walnut Creek, California. And I'm very happy to be here with Jubin. We are between two firms, but it's all inspired by the Between Two Ferns. I have a fern, Jubin doesn't. I'll
get one.
I'm trying.
I'll eventually have one. So let's jump right in. Let me ask a very high level question, which is on a lot of people's minds. Looking at hiring someone as a contractor versus looking at hiring someone as an employee, what are the advantages, disadvantages, just at a very high level? Maybe we can start a discussion there.
So provided you can hire somebody as a contractor, and maybe we can get into that next. From the employer's perspective, it is better to hire somebody as an independent contractor. First of all, you don't have to treat them as an employee for the purposes of the unemployment insurance code, social security, and other taxation laws. So you don't have to withhold their taxes and transmit it to the IRS. You don't have to pay into the 5 different payroll taxes that California mandates employers to do. And you don't have to pay their payroll tax for the federal laws. So it's about, I would say, a 5-10% over the salary or wages or earnings of that worker that you have to pay extra. Plus it comes to have an employee comes with administrative costs of issuing wage statements, making sure those wage statements are accurate and they display all the required, some 16 items that the labor code requires. So not having to hire somebody as an employee has tremendous benefits to you as the employer, and vice versa, it has tremendous disadvantages to the employed entity. They do have to pay their self-employment taxes, which means generally that they are paying that 10% payroll, additional payroll tax on their income. And many people think that it comes with some measure of flexibility, and it does. Although you can hire an independent contractor for a term of a period of time, and then they can't quit before the time expires, or they have to pay you damages if they did quit. So it can tie them down for a longer period of time, or not allow them to leave because they don't like what they are doing, or they don't like how they are treated.
You're talking about the contractor, bringing someone as a contractor.
Yes, so you're bringing someone on as a contractor, then you can have like, you are my contractor for a period of time, or for until this project, whatever I'm hiring you, has ended. And if they quit in the middle of it, and then you have to go out and scramble and hire somebody, and that somebody is more expensive, and you have to spend money on a headhunter, then all of those are damages plus interest. So those are all breach of contract remedies that you could get as the hiring entity if your independent contractor quit before the contract allowed them to, be done.
Now you raised an interesting point. You said, well, assuming you can hire them as a contractor. So, let's explore that a little bit. Why wouldn't I be able to hire someone as a contractor? I mean, I'm hiring them to do something and I'm going to pay them to do it.
So we are live on Facebook. So it depends where you are. You and I are in California, and I'm a California bar lawyer. So my advice is limited to California law. If you have a worker performing work in the state of California, then the law pretty much does not allow you to call them independent contractors. The presumption is that those workers are going to be employees. And there is a specific list of exemptions in the statute called AB5, it's in the labor code, that allows specific industries to hire independent contractors. But if you don't fall into that specific industry, then those people are employees, even if you classify them as independent contractors. So you misclassify them, you are on the hook for at least $5,000, but up to $25,000 penalty for each misclassification. And then all sorts of paycheck penalties, meaning because you did not issue their wage statements, the wage statement did not contain the 16 items that you need to, you did not withhold their taxes correctly. They could not tell how much they were, then potentially you didn't pay them enough money to cover minimum wage, which is a very serious violation of the law.
Wow. So what would be examples of businesses that could in California hire independent contractors?
So for example, us lawyers and architects can hire independent contractors. The law was a little bit complicated about barbers. I think that has been straightened out now, that you can actually have somebody work in your salon, rent a chair, as an independent contractor. So barbers and cosmetologists fall under that. But for most knowledge workers who are not professional employees, the law is that they have to be employees and not independent contractors. There has been another development about gig workers. So that's a subcategory of independent contractor. So after this statute, AB5 was passed, the Uber and Lyft and the meal delivery services put together enough money to run Liechtenstein or another small country and put on a proposition on the California ballot. And that Proposition 22 passed with about a 13% margin, so much more than it was necessary to pass it. I was kind of shocked and surprised. Basically allowing these hiring entities the specific right to classify their app-based drivers and service providers as independent contractors, but as part of the bargain, provide them with some limited employee benefits. So that's a very narrow scope. It covers a lot of people who are doing various amounts of work, but the scope in terms of the general economy is quite narrow because it is only for app-based drivers and delivery personnel. So it has to be related to an app. Say again?
Is that what you mean by a gig worker? Is there a definition for what is a gig worker?
So there is no definition of what is a gig worker. I think if you are a roadie helping people set up bands, then you are not under the Proposition 22, but everybody would say you are working a gig. You have a second job, then you're working a gig. But in this sense of the new, like the gig worker 2.0, the people who work using an app, showing up to a location with their car and either taking food from point A to point B or a passenger from point A to point B, those are exempt under this Proposition 22, which was again passed with a very large amount of cash and a lot of misleading advertisements behind it, I would say. That is my opinion, and I'm going to stick to it. But as a matter of fact, they did agree to provide the independent contractors with some limited benefits. So I guess those workers who were previously just classified as independent contractors, not as employees, did not get any of those benefits. It provided a slim benefit to them. And I think that is why it passed, because everybody understood that they are never going to properly classify and go back and reclassify everybody and compensate everybody correctly. The administrative nightmare that would have entailed was also just too big to swallow for people. So that's how it went. Now it is a constitutional or a change by the voters to the law. It's not constitutional, but like the constitutional protects it from being changed unless there is a specific majority again put on the ballot, and that's so it's going to be a permanent feature of the California landscape. And that's just in California. Of course, Uber and Lyft are now nationwide and even in foreign countries. So God knows where this is going to go, but probably they are going to extend those same benefits globally to all of their workers.
Now, let me just reiterate that a lot of the stuff we're talking about is based on California law. So let's move and talk a little bit about, I have now decided to bring someone on to do work for me. And I'm a company that either is in the technology field or I'm innovating. So I'm not necessarily just labor, but I'm also innovation and technology. What do you need to do to make sure that creation and innovation by either my contractor or my employee belongs to my company and not to those individuals?
Mm-hmm. So you said you're bringing on workers, right? And you didn't really specify if they are independent contractors or employees. So
I'm gonna let you decide which one you want to answer, or both.
Let's start with that angle, which is my angle, and then work our ways into your angle. Okay. So first of all, the way I would analyze the situation, I would look at the statute and make sure that you don't have an exemption from AB5. And if you do have an exemption, then go ahead and classify them as independent contractor. And then comes the next part of the analysis regarding the IP. But if you do not have an exemption, then you have to look at whether you can hire them as independent contractors. And three factors, they come from a case. So they were listed as ABC. So now everybody calls them the ABC factors, are what the court will consider for most of the labor code. And that's another kind of this fine distinction that we can come back to. So under the labor codes protections, you have to classify everybody as an employee unless you, the hiring entity, can demonstrate that these ABC factors are satisfied. So it is satisfied if the worker is free from the hiring entity's control in performance of the work. So you hire an independent contractor and you say, I need you to finish this project, and this is your project, and it doesn't matter how they do it. It doesn't even matter if they do it or their employees or their subcontractors from India. You don't have a right to inquire how they do it unless some other specific laws, such as public contracting laws, come into play. But you as a private entity, you hire someone to finish a project, then they can do it whichever way they want to, then you satisfied A. B is whether the work done is outside of your business, outside of your usual line of business. So for example, let's say that you are a cell phone network, but you don't build your towers. So you hire a subcontractor, an independent contractor entity to build your towers, or you hire somebody to put hammer to nail and build a tower, okay? And you can hire hundreds and hundreds of these people building a tower each, because you're not a tower builder. You can argue that this is outside of your usual line of business.
Don't you need towers to run cell phones? I mean,
you operate the towers once they are built. So yes, you do need them, but that's not your line of business.
Okay.
The building is not you. Somebody else is building it. So that's what I mean. outside of your usual line of business. So they satisfy a need that you have, but they are not a part of your core business. So that's why you're hiring them. And then C is whether they are engaged in their independent trade. So they put themselves out as a tower builder, they have their own shingle, or they have their own advertisement. They go and service other cell phone or other companies that needs towers, for example, Helter Skelters. So go ahead, you hire this tower builder, and the tower builder is now an independent contractor. So ABC has to be satisfied. That's
What's C?
great.
So we've talked about A,
A is whether
control.
they are free from your control in how they perform the work.
Right.
Then B is whether they are outside of your core business. And C is whether they are engaged in an independent trade under their own good name.
Okay.
So usually where it fails is B. B is the hardest to satisfy. For example, if the lawyers were not exempted, so for that 1 year when Dynamics, the case that propounded these ABC or actually pronounced the ABC factors for all industries, I was counseling my law firm clients to not hire independent contractors, hire everybody as employees, because as a lawyer, I practice the law. So everything that a lawyer does is what my firm is supposed to do. So if I hire a lawyer as an independent contractor, the question is why the lawyer is doing the law stuff that you're doing. They are in your core line of business. And even if I say, I never go to court to argue, I can't. That's what lawyers do. So you hire the lawyer, not the lawyer is your employee. So interestingly, if between the Dynamics decision and AB5, if you changed your independent contractors, converted them to employees, and then AB5 came out and said, now they are exempt, you don't have to hire them as independent as employees, you can have them as independent contractors, and they were your employees, you can't convert them into independent contractors. That is a violation of the labor code, and bam, all sorts of penalties come with it. So it was kind of, I think I was kind of draconian, but such is life. So the only thing you can do is basically lay those people off and then hire people who are independent contractors who wants to do that.
Yeah, no, I
Because,
understand.
like, you
So
save
now-
10%, but probably you spend 10% on training someone new.
someone and all the costs associated with that. So now let's look at this. I've determined that I can hire someone as an independent contractor,
Yeah.
either because I'm exempt or I can meet the ABC factors. What's the issue then in terms of ownership of the intellectual property? I mean, how do you advise your clients to deal with independent contractors that are doing something for them that may be innovative? I mean, what happens then?
So now you just walked into the second part of the analysis. So you think you can hire this person as an independent contractor, but you also want to make sure that the work they are performing is going to be your IP and not theirs.
Oh, by the way, let me ask you one question. So if they're going to be hired as employees, you control ownership of what they do through the employment agreement, right?
Yes. So first of all, the employment agreement presumes that they are creating the work for you.
Okay.
Second, you would do well to reinforce this by putting it into your employee handbook and into your offer letter that all work that they create in their employment doesn't really matter when, doesn't really matter what resources they use, just presumed to belong to you.
Okay. So the employee is easier to handle because the law works better for the employer and you can put it in the employment agreement.
Correct. It is quite difficult to handle employees who have like a garage where they are inventing, and then they kind of use a part of their daytime and the part of, they use your computer, your phones, your fax machines, everything for their benefit, and then they go out and start their own company. But if they are not really like competing with you, then you probably won't care. But quite often it happens that they open a competing business and then you have to kind of fight it out.
Yeah, because if you
and
hire a
all of-
software engineer and they go off and make phishing tools, that may be, you don't care. But if they go off and develop software that's competing, yeah, I get your point. I get your
or a software is in that phishing tool somehow, like, when there is okay, I'm just going to invent a software, there is something that indicates there may be a bite, then it sounds an alarm, a vibration on your Fitbit, so that you will, not let this big fish go, and you will reel it in. Oh, that's awesome. But it's still software, and any idea that they conceive while your employee conceivably, pun intended, belongs to you, because you employ them, and there is no way for you or for them to tell when they conceive the idea. Maybe this is really, really valuable. Most inventions are in sports paraphernalia. Golf clubs in particular are famous for, having a lot of inventive materials. So this could be really good money. Maybe you are developing software, you were developing apps, but you're thinking, man, if I could like get the 10% of this fishing rod stuff, that would be awesome. And that's probably how you can negotiate this down. Like, you were my employee, this idea is supposed to belong to me. I'm not really interested in like having a fishing rod business on the top of my business, but give me 10%, I won't give you trouble. So that's one way of doing it. So hiring someone as an employee is the foolproof way.
And
now
what
you have,
if you're hiring them as a contractor then? Now what do I need to think about?
now you have to contract for the IP. And so what you do, what you know how to do, and put in a really nice invention agreement, and you put in a really nice work made for hire clause and an assignment requirement. So everything, all of these three things are covered. It could be like a one really well worded sentence, or a really well worded paragraph, or could be three separate paragraphs. So basically anything they invent while they are working for your project belongs to you, and the work that they create specifically during this project will belong to you, because it's a work made for hire. And if they invent something for this project, then they have an obligation to assign. So I think these are the three principles you want to secure. Okay. However, now you just walked into California's nice trap that is set for you, and it closes on you, because the California Labor Code specifies that any contract that says work made for hire is belonging to the hiring entity is presumably creates an employer-employee relationship. So you wanted to hire this guy as an independent contractor to build your towers, but the tower built and all the IP in the tower, you wanted the IP part to be a work made for hire, and now they are still not your independent contractor, they are still your employees. So what can you do? How can you still hire them and make sure that the IP belongs to you and not have to hire them as your employee? So the only way really to do this, of course, like California wants you to hire them as an employee, but the other way to do this is to have them create their own hiring entity, loaner company, so that they have themselves employed by this company and they are on loan to you. This puts all of these administrative and payroll costs onto the worker, but it can also ensure that you have their IP assigned to you as a work made for hire.
Now you've got an article that kind of explains all of this. So if you don't mind, throw that article, what we can share.
Yeah, I did not just wake up one day and was this smart about it. I had to research and write it. So I'm going to pop in my Workmate for Hire article that I wrote with Natasha Chi, who is an entertainment lawyer. And this really is a very big issue for the entertainment industry, especially the independent film industry. They have a very limited budget and everybody kind of collabs on it. And if they hire each other as independent contractor, they also want to have this Workmate for Hire in there, especially if you think that down the line, there's going to be some derivative right and you want all the rights to belong to you. So now we are working on a film, but then maybe later there will be some merchandising, or there will be a sequel, or there will be a book, there will be fan fiction. Then you want all those rights to belong to you. So you want to put in that Workmate for Hire into your contract. You want to make sure that all of these rights down the line belong to you. How do you go about it and yet not hire these individuals all as employees? We kind of try to figure this out and crack this nut for everyone.
Perfect. We're coming up to the end of our 30 minutes. So do we
Any questions? I love questions.
Yeah, let's get some, if we
Let's get some questions. Do you have any more questions? Yeah.
There is one.
Go ahead.
Sorry, go. You sure? Okay.
Yeah, go ahead.
We do have one question that came in. It is, what if the employee was already working on something, for example, software, before you hired them, and then they continue to work on that as an employee? Would that software be separate, and would it end up as an employer's IP because they had previously done it before they came on board?
I think that's probably a better question for Jubin than me.
Why don't you take a run at it, Marta, and then I can jump in as we go along.
So I think as the hiring entity, of course, you want to capture as much as possible of the intellectual efforts of your employees. So usually you write in your offer letter or employment agreement that they are supposed to use their best efforts for you and only for you. And you want to say that all of their efforts are supposed to benefit yourself, your business.
Yeah.
And then there is also the labor code has a provision that says that an employee, while an employee owes a duty of loyalty to the employer in the sense that they are supposed to put all their efforts in towards the benefit of the employer, even if they are in the same business as the employer. So even if they have began working on the material before, it's going to be a hot dispute how they prove that they have begun that earlier. But after their employment, any improvements, any derivative additions will belong to the employer per the labor code's provisions. And because you contractually, wisely, because Jubin advised you to do so, specify that anything they do, no matter what time of the day, if they came to this in the shower, that duty of loyalty compels them to assign that material to you.
I think one of the things that the question also identifies is the ability of the employer to ask the right questions. You need to, before you hire someone, you need to ask them, hey, are you working on something? What are you working on? What are what are the things that you're doing that might currently impact your employment that you were doing for your previous employer? Because you need to ask them to identify these things so you can address them. Because if you fail to ask and later on they raise the issue, that's a lot harder to resolve than if you ask up front and you resolve it before you hire them, because you may end up not hiring them because of what they worked on. You may decide to move on. So I think the key thing the question is identifying is the diligence to ask and identify, and then lawyers can help you decide how to handle it. But if you don't know about it, you don't know it's coming.
So the prior employer has certain rights to the invention. So whenever you are hiring knowledge workers, specifically with the idea that they are going to create inventions for you, you have to have that kind of disclaimer that I assign everything I created except these, and these are my prior patents, and these are my prior projects that are owned by somebody else, either by me or by my prior entity. But I think the question was like, they started secretly to work on something and now they're finishing it on your time. Maybe I was imagining that was part of the question, but a very good point to have always go, if you are hiring people for them creating your IP, then talk to an IP lawyer, because there's just no better advice than going and having that 30 minutes, an hour. It's, believe me, it's well worth the money to have that preventative lawyering done and have your employment agreement cover those things. I'm pretty sure Jubin has several beautifully drafted paragraphs to drop into the employment agreement. But now you know that if you want to put in a work for hire, then you probably need to think about whether they can or cannot be independent contractors and how you are going to go about it, because that in itself can defeat your plans to hire them as independent contractors. Any other questions?
Nope, that will do us for today, and it brings us almost right on time. So
Ooh.
unless you have any closing statements, we're good to sign out.
Well, it was lovely talking to you, Jubin. Let's
Likewise. Next time,
keep the faucet going. It's like
make sure I
drinking
have
from
my
a
food.
fire hose. Have a
phone.
fern already.
I
Thank
gotta
you
get
so
my-
much. Thank
Yeah,
you.
thank
Yeah.
you.
Have a good day, everyone. Bye-bye.
Bye.